SCOTUS RUCKUS. Produced by InlexVeritas.com.
This is a quick sidebar explainer of the Fair Credit Reporting Act as it relates to the case, Spokeo, Incorporated vs. Robbins. Remember, the case was originally brought in the United States District Court, the Central District of California, the jurisdiction been given over the subject matter of the action pursuant to 28 U.S.C. Section 1331, which states as follows. Quote, the district courts shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. End quote. Here, of course, the statutory law at issue is the Fair Credit Reporting Act.
Since the suit was originally brought under the Fair Credit Reporting Act, I think a little background review of the Act is in order. It might be a little bit boring, but please bear with me. A good introduction is reading the Statement of Purpose section, which goes something like this. Section 602. Congressional Findings and Statement of Purpose, 15 U.S.C. Section 1681. A. Accuracy and fairness of credit reporting. The Congress makes the following findings. 1. The banking system is dependent upon fair and accurate credit reporting. Inaccurate credit reports directly impair the efficiency of the banking system, and unfair credit reporting methods undermine the public confidence which is essential to the continued functioning of the banking system. 2. An elaborate mechanism has been developed for investigating and evaluating the creditworthiness, credit standing, credit capacity, character, and general reputation of consumers. 3. Consumer reporting agencies have assumed a vital role in assembling and evaluating consumer credit and other information on consumers. 4. There is a need to ensure that consumer reporting agencies exercise their grave responsibilities with fairness, impartiality, and a respect for the consumer's right to privacy. B. Reasonable procedures. It is the purpose of this title to require that consumer reporting agencies adopt reasonable procedures for meeting the needs of commerce for consumer credit, personnel, insurance, and other information in a manner which is fair and equitable to the consumer, with regard to the confidentiality, accuracy, relevancy, and proper utilization of such information in accordance with the requirements of this title. The relevant definitions for our limited purposes are as follows. Section 603. Definitions. Rules of construction, 15 U.S.C. Section 1681a. A. Definitions and rules of construction set forth in this section are applicable for the purposes of this title. B. The term person means any individual, partnership, corporation, trust, estate, cooperative, association, government or governmental subdivision or agency, or other entity. C. The term consumer means an individual. D. Consumer report. 1. In general. The term consumer report means any written, oral, or other communication of any information by a consumer reporting agency bearing on a consumer's creditworthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living which is used or expected to be used or collected in whole or in part for the purpose of serving as a factor in establishing the consumer's eligibility for a. Credit or insurance to be used primarily for personal, family, or household purposes. B. Employment purposes. Or C. Any other purpose authorized under Section 604, Section 1681b. The relevant compliance procedures for the consumer reporting agency are set forth as follows. Section 607. Compliance procedures, 15 U.S.C. Section 1681e. A. Identity and purposes of credit users. Every consumer reporting agency shall maintain reasonable procedures designed to avoid violations of Section 605, Section 1681C, and to limit the furnishing of consumer reports to the purposes listed under Section 604, Section 1681B, of this title. These procedures shall require that prospective users of the information identify themselves, certify the purposes for which the information is sought, and certify that the information will be used for no other purpose. Every consumer reporting agency shall make a reasonable effort to verify the identity of a new prospective user and the uses certified by such prospective user prior to furnishing such user a consumer report. No consumer reporting agency may furnish a consumer report to any person if it has reasonable grounds for believing that the consumer report will not be used for a purpose listed in Section 604, Section 1681B, of this title. B. Accuracy of report. Whenever a consumer reporting agency prepares a consumer report, it shall follow reasonable procedures to assure maximum possible accuracy of the information concerning the individual about whom the report relates. C. Disclosure of consumer reports by users allowed. A consumer reporting agency may not prohibit a user of a consumer report furnished by the agency on a consumer from disclosing the contents of the report to the consumer, if adverse action against the consumer has been taken by the user based in whole or in part on the report. Notice to users and furnishers of information. 1. Notice requirement. A consumer reporting agency shall provide to any person, a, who regularly and in the ordinary course of business furnishes information to the agency with respect to any consumer, or, b, to whom a consumer report is provided by the agency, a notice of such content of notice. The Bureau shall prescribe the content of notices under paragraph 1, and a consumer reporting agency shall be in compliance with this subsection if it provides a notice under paragraph 1 that is substantially similar to the Bureau prescription under this paragraph. The civil liability for willful non-compliance is as follows. Section 616. Civil liability for willful non-compliance, 15 U.S.C. Section 1681 (b) in general. Any person who willfully fails to comply with any requirement imposed under this title with respect to any consumer is liable to the consumer in an amount equal to the sum of a. Any actual damages sustained by the consumer as a result of the failure, or damages of not less than $100 and not more than $1,000. Or, b. in the case of liability of a natural person for obtaining a consumer report under false pretenses or knowingly without a permissible purpose, actual damages sustained by the consumer as a result of the failure, or $1,000, whichever is greater. 2. Such amount of punitive damages as the court may allow. And, c. in the case of any successful action to enforce any liability under this section, the costs of the action together with reasonable attorney's fees as determined by the court. D. Civil liability for knowing non-compliance. Any person who obtains a consumer report from a consumer reporting agency under false pretenses or knowingly without a permissible purpose shall be liable to the consumer reporting agency for actual damages sustained by the consumer reporting agency, or $1,000, whichever is greater. Additionally, the civil liability for negligent non-compliance is as follows. Section 617. Civil liability for negligent non-compliance, 15 U.S.C. Section 1681 (a) in general. Any person who is negligent in failing to comply with any requirement imposed under this title with respect to any consumer is liable to the consumer in an amount equal to the sum of 1. Any actual damages sustained by the consumer as a result of the failure, and 2. In the case of any successful action to enforce any liability under this section, the costs of the action together with reasonable attorney's fees as determined by the court. B. Attorney's fees. On a finding by the court that an unsuccessful pleading, motion, or other paper filed in connection with an action under this section was filed in bad faith or for purposes of harassment, the court shall award to the prevailing party attorney's fees reasonable in relation to the work expended in responding to the pleading, motion, or other paper. There is a section on jurisdiction as well. I will just read it here for reference. Section 618. Jurisdiction of courts. Limitation of actions, 15 U.S.C. Section 1681p, an action to enforce any liability created under this title may be brought in any appropriate United States District Court, without regard to the amount in controversy, or in any other court of competent jurisdiction, not later than the earlier of 1. 2 years after the date of discovery by the plaintiff of the violation that is the basis for such liability, or 2. 5 years after the date on which the violation that is the basis for such liability occurs. This has been a quick rundown of the Fair Credit Reporting Act as it pertains to Spokeo v. Robbins.